Namaste students. Today's topic is oral evidence. Kindly take two questions from this topic. Start inverted comma. Oral evidence must in all the cases whatsoever be direct. Close the inverted comma. Put a full stop. Explain with exceptions. Another question. Start inverted comma once again. Hearsay evidence is no evidence. I repeat. Hearsay evidence is no evidence. Close the inverted comma. Put a full stop. Explain. So, if this is the question, this is your answer. For that question, your answer must contain these points. Right? Very simple. You know, there are three principles in the Indian Evidence Act. The first principle is called proof by relevant fact. Section 5 to Section 55. Second one. Hearsay evidence is no evidence. Okay, we will concentrate this one. See the word. This is a single word. It is a combination of two words. Here is one word and say is another word. Hear and say. In our country, there are people who are called gossip mongers. They always spread the rumors, though they have not seen anything from their eyes, but they will talk nonsense, they will concoct the story. You know, they will say that is like this is like that. You know, they simply keep on telling to the world unseen, unknown, you know, concocted, fabricated points. Okay, so what is this hearsay evidence? Let us understand that God has given us 5 physical senses. All of you know this, all of you have it. You enjoy these physical senses. God has given the ear to listen good things, and the nose for smelling, and the skin to feel the touch, and the tongue for the taste, and the eye to see or to view the things happening in our vicinity. These 5 senses will always be useful to each and every human being. They are the means to gain the knowledge. And you know, we will get direct information, direct knowledge from these 5 senses. Right? So, in the law of evidence, you know, the law says, according to section 60, whoever comes to the court of law as a witnesses, they must have the first-hand information. They are the direct perceptors of the knowledge. Only such witnesses are allowed in the court of law. It will not entertain the indirect or the third party informers or the person securing the fourth party, fifth party information. No, they are not allowed to come and give the witnesses. For example, if I have seen a killing on the public road, yes, I am an eyewitness. I have the right to go to the court of law and give the evidence as follows. At this date, at this time, I was on the road. In this particular road, I saw this man accused chasing the victim and killing the victim. So, I have the right. I am the direct perceptor of that killing. So, oral evidence I am giving in the court of law, it should be always the first-hand information. Understand? Yes. So keep it in mind. This one, law do not respect any gossips, any rumors. To tell you, I would like to give a small cases. The first one is R versus Gibson, 1887. One day what happened? A road. One Mr. A, he is coming, bowing his head down. He was taking a walk. Neither he is looking at that side or that side. Suddenly, one stone came and hit his head. He do not know who has thrown the stone. He started bleeding. One lady was walking on the street. She told him, see, the one who attacked, caused the injury, he is in this house. The lady indicated that house and went away. She never seen later. This victim, he went to the doctor, then to the police, and then information to the police, and there, according to the information, the police came and took action on that person, that indicated house, and he was taken to the station and the case commenced. Before the court of law, during the trial, the judge asked him, have you seen from your eyes that this man has thrown stones at you? Have you seen? But this victim says, no. He sincerely told, no, Your Honor. I have not seen from my eyes. I heard from a bypasser that the one who attacked you is in this house. I gave the same information to the police and I have not seen. Then the court said, this is an indirect form of oral evidence. It is a hear and say evidence. We are not going to give validity to that kind of evidence, and he was acquitted. Okay, this much small illustration enough. Now let me take one more example. Tepper versus R, 1952. This is the case of a husband and wife. One day, a policeman, a traffic policeman, was on duty. The road was very busy. So many vehicles are moving. There is a shop here, and the owner of that shop is a lady. There, the shop was on the fire, and the lady started shouting, indicating in that direction. The words of the lady is as follows. Hey, you, going away when your shop is burning. She was shouting, 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 indicating the hand in the direction. This constable, he has not seen who has set the fire. He do not know anything. And this fellow called the other policeman and they went and arrested the husband of that lady. And the husband was charged that you are the person who set the shop on fire. But who is the evidence? Eyewitnesses. Who are the eyewitnesses? Who have seen the setting of the fire by the husband? And the court said, Mr. Constable, have you seen from your eyes? No, Your Honor, I have not seen. Then they say, how can you believe, imagine yourself about the setting of fire by the husband? No, and the husband was acquitted. So, all of you, direct evidence. It should not be an indirect oral evidence. The court will not accept it. Now we will go to the exceptions. What I have told you now, oral evidence must be direct, it should not be indirect. There are exceptions, and in these exceptions, I am giving you only 5 points. In these 5 exceptions, the information is indirect. Information is indirect. Then, in these 5 circumstances, the indirect information or the third party information is also relevant. Right? Now, all these topics I have already done. I have already taught you. Okay? Now, I will give you some 4 or 5 sentences on every topic. First one, res geste, section 6. Res geste means parts of the transaction. Okay, kindly refer section 6, what I have taught you. I don't want to repeat. Now consider, I would like to give one small illustration here. A dispute comes about a will. And there is a first wife and the first wife's 3 children, second wife having one girl child, and there is a dispute between the first wife and the second wife about the sharing of the husband's property. Husband has written a will giving equal property to both the first wife and children, second wife and the child. Now the question is, the first wife says, no, this should belong to me. The first wife says, this will is a bogus will. I am the first wife, I have the right on all the property. And the second wife produced the husband's friend in the court of law as a witness to give the validity to the will. And that husband's friend comes and tells the court as follows. Your Honor, I have not visited their house. No, I have not visited. But my late friend has told me that the first wife is a demonic personality. She is having 3 sons who are about 20-21 years of age. All are criminals. My friend has told me, Your Honor. That's why I took him to an advocate. I got the property, by means of will to be partitioned, to be gone to the first wife and the second wife. So remember here, the court accepted the view, the witness of the friend, even though he has not seen the happenings in the house and the family of the testator. And it is considered as part of res geste, or the parts of the will, the family matters, the pain in the family, the harassment, cruelty of the first wife is called res geste. On that, oral evidence, an indirect oral evidence is accepted. Okay, that much is enough. Now we'll go to another topic, that is admissions. I have taught you section 17, 18, 19, 20, 21. We the people, whatever crime we do, whatever wrong we do, whatever mistakes we do, whatever violations we do, we are going to accept our wrongs, our faults, our mistakes, our negligence. Then we may tell to others how we have made mistakes in our life. And the one who listen from us, they can come to the court of law, even though they have not seen the crime by me, but they can come and give the evidence in the court of law as a valid admission. Okay? So, indirect form of evidence is valid. Dying declaration, section 32, subclause 1. Unnatural death. The victim suffering death is going to tell the truth. And he will tell the truth to a doctor, or to a relative, or to a police officer, or to a magistrate. They have not seen the crime, remember. They have not seen the crime, but they will record it. They will listen, record it. Such recording will be an indirect form of evidence. It is a valid evidence. Public documents. I'll just like to give only one small example. All of you know. Constitutional law of India. There is an article called Article 14. Equality before law and equal protection of law. Any man can come to the court of law and they can speak. Article 14 means equality before law and equal protection of law. Constitution is a public document. Now the question is, have you seen who has written the Constitution? Have I seen who has written the Constitution? No, we have not seen. We have only heard. We have only heard from others that this person has written, Assembly has written the Constitution. But we can orally tell that this is the law. Okay? So it is an indirect form of evidences. Expert. I told you, an expert will not be on the spot of the crime. He will only come to the spot of the crime. He will conduct the analysis and he will give a report. So his report is not directly seen by him. It is only the mental analysis. Okay? How the crime has taken place. He will give his report. That's all. For example, a doctor, when he opens the dead body and he finds out, he collects the viscera, examine, and he will tell that this man was murdered. It is his mental analysis. Has he seen the murder? No, he has not. So, the report of the medical doctor, analyzing the murder, yes, it is an indirect form of evidence. Okay? So, enough of today. I have explained all these points in detail. Okay? Take one para or half of the pages for every point and then you analyze. So, your answer will be full. Okay? So, enough for today. Thank you.
Thank you very much, sir.
Sir.